What's up, everybody? Welcome in. We've got a kind of a short one today, reacting to a clip that some of you sent me. And while it's a short clip, it's less than 2 minutes. We get a couple questions answered that we have had since we heard about the threatening calls James Crumbley made from his jail cell, which limited his contact with the outside world during his trial to just with his attorney or with legitimate members of the clergy. And we also hear from his lawyer for the first time post-trial. It looks like this is a clip from a smaller interview. So if any of you guys find the bigger interview, the longer interview, let me know, send it to me. I'm sure there's going to be more we can react to because just this little soundbite that she gives is really interesting and shows how this trial could have been very different. So those are going to be kind of the two things we focus on, what his lawyer had to say, and we find out who he was threatening from his prison cell. So make sure everybody likes the video. If you haven't already, hit that thumbs up button and make sure you subscribe to our YouTube page so we can continue this conversation together. We are going to get to that interview now.
About the reported threats James Crumbley made while he was behind bars.
And we're also hearing from the attorney for the Oxford school shooter's father for the first time and why she believes her client is innocent. Priya Mann joins us now with more. And Priya, she believes the public has the wrong impression of James Crumbley.
Yeah, that's right. And that's something she tried to get across, especially in her closing arguments. But let's first get to some of those alleged threats that were made. The Free Press is reporting that James Crumbley allegedly threatened Oakland County prosecutor Karen McDonald in conversation.
So there's the person he was threatening, the prosecutor, Karen McDonald. Before we continue on the interview, right in the live chat, what do you think those threats were about? What do you think they focused on? What do you think he threatened her with? Because in these kinds of cases, first off, it's not unusual for a criminal defendant to say nasty things or threaten the prosecutor that's prosecuting them or law enforcement. It's actually not that uncommon in civil cases for defendants to say things to me, to threaten me or say nasty things to me, or for my clients to not like the defense attorney if they were a jerk in cross-examination or whatever it may be, or they felt like they overstepped in cross-examination. So not that unusual, but in this case, it limited his contact with the outside world. So what do you think those threats were about?
Conversations with his sister, Crumbley allegedly said he was going to make it his goal to destroy McDonald's life. Well, the Free
So he was in, I'm going to back it up just so we can hear it one more time. He was having conversations with his sister. Okay. So family conversations. He knows they're recorded at this point. So still a very bad idea to do this on things that are going to be reviewed by law enforcement and by this prosecutor that he's quote unquote threatening. But then we hear the threats and it's that he's going to make it his life's mission to ruin her. I think he said life or career. We're going to listen to it again. My guess is this has a lot to do with people talking about how this is politicized. This is political. She's making an example out of these parents. And James Crumbley probably is on board with that because if you think about it, whenever you're in a situation and people give you, I don't want to call it an excuse, but a reason why this is happening and it's not your fault and it's so unfair and this shouldn't be happening to you, it's hard not to jump on that bandwagon. So from his perspective, maybe he means ruin her political career, or maybe he was making a physical threat to her. And if he was making a physical threat to her, that could lead to its own charges, right? You can't threaten government officials. You can't threaten prosecutors that are prosecuting you with legitimate, real threats. So we'll see if anything more comes of this, but we're going to listen to just that little part of the clip again.
Allegedly threatened Oakland County prosecutor Karen McDonald in conversations with his sister. Crumbley allegedly said he was going to make it his goal to destroy McDonald's life. While the Free Press reports the calls dated back to 2022 and last year, prosecutors.
The calls dated back to 2022 and last year, which was 2023, but they didn't ask to limit his phone contact until now. Why do you think that is? That's a very interesting snippet and part of this. And I have a couple thoughts. And these are just guesses as to why a prosecutor would wait until the middle of trial where all the cameras are on and everybody's watching to say something about this and vaguely discuss threats from his jail cell. And that's why he was a little confused. He's like, what the heck? I've been talking about this stuff for 2 years. Now it's a problem. So number one, it could have been for the cameras, which is exactly what the defense attorney said, that all this stuff is going to come out in front of the cameras right now. Do we really want to do this? That's number one. Here's number two. maybe when the prosecutors were listening to this stuff and like, how could this guy be so dumb to threaten the prosecutor prosecuting his case, the county attorney? How could he be so dumb to do this? Let's not even let him know that we're planning to use any of these jail calls against him or for any negative repercussion. Let's not even let him know, because maybe he'll say something that can help us. Maybe he'll say something else dumb that we can play and use during his trial. So maybe they didn't want to cut that. That tells you right there that they don't find the threats too legitimate between him and his sister while he's sitting in his jail cell. But number two, I think they wanted to keep those lines of communication open in case he did say something, make some admission that they could use against him in the criminal trial. It's just my guess, but that's the only reason I can think of why they wouldn't just nip it in the bud as soon as they heard the threats for the first time, if they felt like those threats were legitimate.
Prosecutors waited until the middle of Crumbley's trial to bring it up. He was then only allowed to talk to his lawyer and a member of the clergy. And last night, for the first time, James Crumbley's attorney spoke out since his conviction and that gag order was lifted. Take a listen to what she had to say in response to the Free Press report that Oxford school officials who testified were assured that they would not be prosecuted.
So she's reacting to a report that Oxford County school officials knew, or there was some agreement that they were not going to be prosecuted. Now, we heard that in the interview yesterday from Karen McDonald, the state attorney that tried this case. And she said there would be no criminal charges. We'd already know about that. But we haven't heard about an immunity agreement. We didn't hear about that during direct, during cross. There's so much that we did not hear and know about that could have affected the trial. Let's see what the defense attorney thinks about this, or if she even knew about this.
If there were immunity agreements, then it's possible that that could have been addressed during cross-examination. And who knows if the jury would have cared. But I may have approached it. I may not have. I can't say for sure because I didn't have the information.
So she's talking about how in just that little soundbite, that's one piece of information she didn't have that she could have cross-examined the school employees on, that maybe the jury would have looked at and been like, wait a second. All we hear about is the parents. The school didn't know this, school didn't know that. The school knew plenty, and they knew enough to where the state had to give them immunity agreements for them to even come testify. In the past, we've had discussions and people say, yeah, those immunity agreements, sometimes it makes a witness a little less credible than another witness. It absolutely would have been something worth discussing, and something that I think the defense absolutely should have known about if they exist. Now, there doesn't have to be an actual written immunity agreement for them to just say, we're not going to prosecute anybody else, and then the school officials to agree to testify, which then the state could, of course, go back on that if there is no immunity agreement. But it's really interesting to me how all this is playing out.
And she was also asked about why James Crumbley did not take the stand and testify in his own trial. And she said that's because the jury did hear audio and video recordings of his interactions with police. Both Jennifer and James Crumbley will be sentenced on April 9th. Reporting live this.
So that very last question, she was asked, James Crumbley's lawyer was asked, why didn't he testify? Jennifer Crumbley testified, why didn't he? And it's exactly what we thought. There was already so many of his statements, explanation of what he did that day, text messages, mapped out data for where his car went. What was he going to say? What was he going to say that was going to help his case? When there's that much recording, there's two ways. Either you have to fill gaps, or it's so bad you have to explain it, or it just is what it is. And for James Crumbley, I felt like it just is what it is. Wasn't great. He was negligent. He didn't do everything he could. Did it rise to criminal negligence was the question for the jury. I don't think he was going to be able to get up on that stand and convince them otherwise. You guys let me know if you think he should have testified. It was pretty clear his lawyer felt like he didn't need to. His statements were already on there. And it did absolutely seem like he was following his lawyer's advice. And he was listening to his lawyer. And I think she did the best that she could with what she had. There was a juror interview with the foreperson of the jury. It wasn't recorded that I've seen, but there was an article about it. And he mentioned the defense lawyer, and he said he thought she did a great job for what she had, but her hands were kind of tied. She had a bad case. And it all came down to securing the firearm. And there's nothing James Crumbley was going to be able to say to convince that jury. He secured the firearm enough to prevent Ethan Crumbley from having access to it. Therefore, if that was the most important point, him testifying, I don't think would have helped. But wait, there's more, because as we've been recording this and going throughout the day, more information has come out about the threats from jail from James Crumbley and a more extended clip, a 4-minute clip now of the same interview, I believe, with James Crumbley's attorney. She's at least sitting in the same spot and repeats some of the same stuff. So we're going to watch that so we can get more information from his attorney. And real quick, I'm going to tell you what I found out about those threats. So he didn't just threaten her political career, but he made comments to the effect of, she's going to be in hell soon, when referencing Karen McDonald, the prosecutor, and talking to his sister. So those threats could absolutely rise to the level of maybe hurting her, doing something to her, having somebody else do something to her, or just hoping and praying for bad things to happen to her, right? And so at this point, no criminal charges have been filed based on those comments, but the threats may be nastier than you would imagine from James Crumbley. But again, not something that's that unusual in the criminal world or the legal world in general, because certain times parties hate lawyers on the other side. So now let's jump back into a 4-minute clip from the interview from James Crumbley's attorney, where we hear even more about what happened at trial, what she thinks about sentencing, and even more.
For the first time, she spoke with NBC News, and she said that James was shocked when he heard the verdict.
We know that James didn't know what his son was planning. We know that he didn't know that his son had obtained access to the firearms, any of the firearms in the house. He wasn't aware that his son had taken a firearm that day. And we really felt that we had shown the jury that he didn't know, and he had acted.
So like most times after an attorney loses, but they feel like they have a good case, they feel like they have a good argument, they make the same argument in the media or to the people that they made to the jury, even if it didn't work for the jury. And that's basically what she's saying. That's our story. We're sticking to it. He didn't know. And if he didn't know, he couldn't be guilty.
Based on the information that he had, and that he didn't know what his son was planning.
We heard from the jury foreperson told the Detroit Free Press that it came down to storage of the gun and not getting Ethan mental health help.
And so we've made some comments on this and got my thoughts on it. But now, more importantly, we're going to get the thoughts of the actual defense attorney. What does she think when she hears that the foreperson focused a lot on not locking up or securing the firearm, and then secondarily, not dealing with the mental health issues?
Your thoughts on that?
And again, remembering Karen McDonald, the end of her closing argument that she felt was effective, and a lot of other people, and how it took her, 10 or 15 seconds to put that lock on that we're seeing on the screen.
I understand that that was his reason, and those were issues for the jury. Obviously, we're disappointed by the verdict, but I did see the article. I do know that those were the reasons that he gave.
You better believe she saw the article, and there's nothing wrong with that. You should do that as an attorney. If jurors are talking about your case and your trial, and you can learn something from it, especially when there's going to be an appeal and maybe even a second trial, you should be reading, watching, and listening to what people are saying, what the jury is saying. They're the most important people in the room. They were the ones you were trying to convince. You weren't able to convince them. Why? And again, he complimented her. But we are going to really learn a lot as we hear the jurors, the appellate arguments, and things going forward in this case.
Do you think the outcome would have been different had James testified?
No, I don't think so. The jury heard from James. They heard him in his interviews. There were, I think, 4 videos played, and then also the 911 call. They heard from James. They heard what he would have said on the stand. So I don't think
we kind of already commented on this, so we'll just keep listening.
That they would have heard anything different from him than what they'd already heard.
And can you talk about what sentence you all will request next month?
I am going to be filing a sentencing memorandum where I will request a potential sentence, but I haven't done so yet. So once I file that, then we'll make the decision on what I'm asking for.
How is James?
So she's got to go through, she's got to get her research. She's got to get the letters and comments and statements on behalf of James Crumbley. She's got to look at the guidelines before she even puts her memo together to send it in. So at this point, she doesn't even know what she's going to request as a reasonable sentence. My guess would be somewhere around the time served range, and then probation and other things that they can try to get around to make it a sentence that's palatable to the judge. Probably not going to happen, but that would be my guess of what she requests.
James doing today?
I don't know if there's a minimum mandatory. If there is, obviously she can't request less than that unless there's a reason for a downward departure.
He's okay. He's disappointed, but we're taking everything one step at a time.
Has he been able to talk with Jennifer? Are they able to communicate?
So that's a question a lot of people had. And, I assumed the answer was no, but they're not communicating right now. But she talks about when the last time is that they did communicate. And that's interesting.
So at sentencing, will that be the first time they talk or see each other?
No, they've seen each other before trial. Before each of their trials, they've seen each other. But since each
So
of
they
their
saw
trials,
each other before each of their trials. That's really interesting to me.
yes, that will be the first time.
Did Jennifer's trial?
I would assume any communication they had was either supervised or recorded. So it was nothing, nefarious going on. But it's interesting to me that they did see each other before each of their trials.
Happening before James helped you with your Jennifer's?
Seen each other. But since each of their trials, yes, that will be the first time.
Did Jennifer's trial happening before James help you with your strategy, or was it an advantage or a disadvantage?
A question a lot of you had. Did she change her strategy once she saw how Jennifer Crumbley's strategy, I'm a vigilant mom and we're all bad parents, don't convict somebody for being a bad parent? Did that change the way you looked at this case, change the way you argued this case? I always thought it was no. I felt like she had her theme. She had her way that she was going to argue, and I thought it was more effective than Jennifer Crumbley's, but let's hear what she has to say. Did she change her mind on what her strategy and arguments were going to be at trial?
I can't really say for sure. I've kind of always viewed this case the same since the beginning. James didn't know. He had no reason to know. He had no reason to suspect anything. And that's kind of been my approach the whole time. So that didn't change. And Jennifer's trial going first didn't change that.
And that's not a surprise based on how she attacked all the witnesses, because we've done depositions or, pretrial statements and things before. So we kind of knew what the witnesses were going to say. And she planned out her cross-examination or opening statements or closing argument, how she was going to do. You can't change all that in a couple weeks just because you saw some other trial. So it's unusual for lawyers to do that. Maybe little tweaks here and there. I'm sure things happened. She learned, she, got some information. It may have helped a little bit, but I would be shocked if they changed, completely what their trial strategy was.
Does he still communicate with Ethan in any way? Do they write letters to each other?
No.
Now I'm curious, your team requested that Ethan's journal would not be allowed into evidence and that some of the video would be kept out.
So those are big issues, though, because those could be appellate issues if she thinks the court made the wrong decision by letting them in. So let's hear what she says.
If that had have been granted, if that request was granted, do you think the outcome would have been different? Do you think this was an emotional verdict?
I think it could have been different. Again, I'm not going to fault anyone for any emotions that were involved. As I said throughout the trial, it was an incredibly emotional trial. There was incredibly emotional evidence that was presented. It was in Oakland County, which, by itself heightens the emotions a bit because people in Oakland County are more directly affected by what happened at Oxford High School than people in another county. So I don't fault anyone for that, but I do think that if the journal and the video had not come in, that things could have been different. I mean, we can't say because it didn't happen that way, but it's always possible that things could have been different.
And those are huge pieces of evidence. So if they were improperly admitted, I can almost guarantee the court's going to overturn this verdict. Now, were they improperly admitted? I'm not so sure, but the decision for the appellate court will be on their admission. Was it proper? Because, she's saying, could it have been different? Maybe it would have, maybe it wouldn't have. I think if the court finds that they were improperly admitted, that they're going to find it was reversible error. But we'll see if they do take issue or if they agree with the trial court judge that they should be admitted.
And you wonder if that's going to be a point of appeal.
I don't really wonder. I am pretty sure it's going to be a point of appeal. But I appreciate all you guys joining me. We got some more information. I wanted to make sure we clipped that in. I'm between seminars right now, just popping in to do a quick video. I might do a couple more of these. Let me know if you guys like just the short kind of 10-minute videos, or if you'd rather just wait till whenever I have a day to do a longer live. I might mix one in if something does pop up and I have time to do it. But I appreciate you guys joining me. Always from all over. It's great to know you guys. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.